And now I would like to welcome Andrew Robb. Andrew Robb is the managing lawyer of the Disability Law Clinic at Disability Alliance BC. The Disability Law Clinic is the first community legal clinic in BC that practices exclusively in the area of disability rights law. Andrew, thank you for being here today and your patience. I'll pass it over to you now.
Well, listen, I'm happy to be here, and thank you very much for that welcome. And I'm sorry about these technical issues. I have a feeling they might be my fault, but honestly, I'm not sure what happened there. So I appreciate everyone's patience with that. I will start by just introducing myself a little bit, just so you know my background. I've been a lawyer for about 12 years in Ontario and Alberta, and then most recently here in BC. I have spent pretty much my whole career in the nonprofit sector, typically assisting clients who can't afford to pay for legal services. And I've been with Disability Alliance BC since March of 2020, about 3.5 years now, working with our program called the Disability Law Clinic. And I want to thank you for being able to advance the slides for me. I'm sorry that I can't do that myself because of our technical problems. Can you please go to the next slide? Thank you. And so I want to acknowledge, as it says there, that this presentation is being broadcast from the traditional, ancestral, and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. And I want to acknowledge that I am a grateful settler on those lands. So I want to give the outline of my presentation. First, I'm going to talk just briefly about Disability Alliance BC, or DABC, and the Disability Law Clinic where I work. And then I'm going to start the sort of legal education or the legal presentation part by discussing, first of all, human rights laws in Canada, including some important concepts to understand like disability, discrimination, accommodation, and undue hardship. And I'm also going to talk about the duties and responsibilities of employers and employees. Can we just go back one slide, please? Thank you. I'll also then talk about what kind of accommodations can you ask for as an employee and what to do if your employer refuses to accommodate you. Finally, I'm hoping I'll have time to talk a little bit about a new type of law that we've seen in Canada recently called an accessibility law, as well as accessibility standards. And then I will do my best to make sure we have some time for questions at the end. And I do encourage anyone who wants to insert questions in the chat at any time during the presentation, and I will do my best to answer those as we go along. And if I don't get to it as we go along, I'll try to get to it at the end. Next slide, please. Thank you. So as it says here, the mission of Disability Alliance BC is to support people with all disabilities to live with dignity, independence, and as equal and full participants in the community. We have been around for about 45 years. And the Disability Alliance BC operates several programs. Mainly, they assist people with disabilities to access government programs and benefits. Next slide, please. So the Disability Law Clinic is a relatively new program of DABC. We provide free legal services to people with disabilities in certain areas of law, including human rights, social assistance, and decision-making rights for adults with disabilities who are subject to guardianship or trusteeship. As it says in the slide, we also try to help with accessibility laws, disability-related human rights cases, access to services, including post-secondary education and public transportation, accommodation and housing in the workplace. I already mentioned decision-making rights. Oh yes, and also legal issues related to mainly to long-term disability insurance benefits. So that's everything I wanted to say about DABC and the Disability Law Clinic. Next, I'm going to talk for a bit about human rights laws in Canada. And so one thing that's important to know is there are at least 2 different laws about human rights that apply in every province and territory in the country. One of them is created by the federal government in Ottawa, and that's called the Canadian Human Rights Act. And also every province, including BC, has its own provincial human rights code. Here in BC, it's just called that, the Human Rights Code. And these 2 laws, the federal one from Ottawa and the provincial one here in BC, they're based on similar principles, but they work in sort of different ways. And this can be complicated because both the Canadian government and the provincial government have a role to play in preventing discrimination, but in different areas of life. And it's the Constitution of Canada that says what areas of life are under federal government control and what areas are under provincial government control. And frankly, this gets confusing even to me, trying to figure out if this is a federal government issue or provincial government issue. So all I will say for now is, if a person is considering making a human rights complaint, it is definitely best to get advice from a lawyer about whether the issue you are concerned about is under the control of the federal government or the provincial government here in BC. Certainly, it can be a little more complicated than what I've just described, but I don't want to get too deeply into that right now. So this next slide talks about what it means to, in legal terms, to have a disability, because human rights laws protect against discrimination based on disability in the workplace. I should say this presentation is focused on disability and discrimination in the workplace, but human rights laws also protect people from discrimination in other areas of life, such as housing or education or healthcare and other government services, as well as services from private businesses. So for example, your landlord is not allowed to discriminate against you based on your disability, and neither can your grocery store, for example, or any other store, or a school or some other type of service provided by the government. But here, of course, I'm focusing mainly on discrimination in the employment context. And so going back to the slide, as it says there, human rights laws define disability very broadly. Sometimes people ask us, well, does my medical condition count as a disability for legal purposes? And usually the answer is yes. Disability in human rights laws includes all types of mental and physical disabilities. It includes temporary or permanent disabilities, and it includes visible or invisible disabilities, even if other people can't tell that a person is disabled. Next slide, please. Thank you. And so so I tried to explain sort of what a disability means for legal purposes. Next, I want to try to address what counts as discrimination. And it can really mean any action or decision that causes a negative impact on a person based on their disability. For example, firing someone could be discrimination, reducing their salary or their benefits. Any kind of assault or harassment in the workplace can count as discrimination. And then the main thing I'm going to talk about today is discrimination by failing to offer reasonable accommodation. And I want to stress that these actions don't necessarily constitute discrimination. It's only discrimination if these types of actions are caused by or closely related to a person's disability. Or it could also be connected to another, what we call a protected ground. So as it says in the slide, the definition of discrimination doesn't just apply to disability. It also applies to actions or decisions related to other protected grounds, such as race, religion, sex, sexual orientation, or gender expression. And this list of prohibited grounds of discrimination, it varies a little bit depending on which province you're in or whether your employer is regulated by the federal government versus the provincial government. But all Canadian human rights laws are generally similar in that they protect people from discrimination, certainly on the basis of disability, and also on the basis of these other grounds I've listed here, or something very similar to that. Next slide, please. Thank you. So now I'm going to talk about an employer's duty to provide reasonable accommodation. As it says there, in order to avoid discrimination, every employer has this duty to provide reasonable accommodation up to the point of what we call undue hardship. And the undue hardship idea is a little bit complex, and I'm going to talk about that in just a moment. But I want to talk more about accommodation first. As it says there, sometimes treating people fairly means treating them differently from other people. And that's why the law includes a duty to accommodate. And this is a responsibility by the employer, in our case, to take reasonable steps to provide accommodations that an employee needs in order to do their job. I'm going to talk a little bit more about this right now. This is how avoiding discrimination is connected to the employer's duty to accommodate. The employer has to accommodate employees with disabilities in order to avoid discriminating against them. But the word reasonable is important in this context. The legal obligation that an employer has, that your business or your employer has, is not to provide a perfect accommodation or to provide exactly the accommodation that the employee has requested. The only requirement is it must be reasonable. And this means that sometimes employees must be willing to compromise. You're not supposed to reject an employer's reasonable offer of accommodation unless they have a very good reason. Excuse me, unless you have a very good reason to reject the offer, unless the offer of accommodation just doesn't work for you at all and there's no chance that it's going to work for you at all. It's supposed to be, the accommodation process is supposed to be a cooperative process where the employee and the employer both have to do a little give and take, right? There's supposed to be room for compromise on both sides. But there's a limit to that. And in legal terms, the limit to the duties, the employer's duty to accommodate is what we call undue hardship. So can we please go to the next slide? Thank you. So what undue hardship means is there is a limit on the employer's duty to accommodate. If an accommodation would create undue hardship for the employer, then the employer is not required to do it. But I want to stress that undue hardship is rare. Most accommodations require some amount of financial cost for your employer, but just because they cost some money, that does not mean that they require the employer to use undue hardship. The cost must be very high for the employer to use this as an excuse not to accommodate you. Some accommodations for one worker might inconvenience other workers. For example, if one person has to change their shift or the place where they work to accommodate their disability, that might mean that another worker has to accept those changes, and that might not always be convenient for the other worker. But inconvenience alone is usually not enough to count as undue hardship. Other employees, your colleagues, are sometimes expected to change the way they work and make compromises themselves in order for the employer to accommodate you as a person with a disability. The specific circumstances of the case are very important in figuring out what counts as undue hardship. For example, a really expensive form of accommodation might be an undue hardship if the employer is a small business, but not if it is a big company with lots of resources. And for really big employers, like for example, the government, the financial cost of an accommodation almost never counts as undue hardship because an organization like the government has maybe not necessarily unlimited resources, but they have a great deal of financial and other resources. So looking at the slide, it says there, the law weighs several factors together to decide what counts as undue hardship. Financial cost is one of them. Health and safety risks are another very important consideration in accommodation. And often when an employer can prove that the accommodation would create health or safety risks, most of the time that does count as undue hardship. But again, it's going to depend on the size of the employer and the resources available to them, because in some cases, a big employer with a lot of resources can mitigate those risks, can take other actions to make sure that any health or safety risks are not too severe. And as it says there, the law also considers the impact on the rights and interests of other workers for accommodating the worker with a disability. But as I said earlier, sometimes other workers are required to accept changes or inconveniences in order to make sure that all employees are accommodated. Can we go to the next slide, please? Thank you. So this slide is about the employer's responsibilities. And I want to start this one by saying that in my office at the Disability Law Clinic, we very often get questions about how much information a person has to provide to the employer in order to support their request for accommodation. And it can sometimes be a tricky question because it depends on the circumstances of the case. But in most cases, the employer is allowed to ask for a note or a report from a doctor or another kind of healthcare provider to support the request for accommodation and to explain how the accommodation is connected to the person's disability. However, I should point out that if the employer gets a note like that, if they request a report from a doctor, the employer is required to pay the costs of getting that note or report if the doctor can't do it for free. Turning to the slide, it says a few other things that the employer has to do if an employee has requested accommodation. As it says there, the employer must consider what accommodations they can offer. They can request only the information they need in order to determine how to accommodate the employee. They're not allowed to request any kind of information. They have to focus their request on relevant information about how your disability affects you. If there is no accommodation possible for the position, the job that you're in, some employers, depending on how big they are and how much resources they have, sometimes they must consider whether another position could be made available for you. All employers have a responsibility to maintain confidentiality about your request for accommodation and your disability. They're not entitled to tell all the other workers there about it. In fact, they're not supposed to tell anyone unless that person needs to know they're only supposed to tell people what they need to know in order to accommodate you. The employer is not supposed to share any other medical or personal information about an employee who requests accommodation. And the last thing it says here is employers must respond to requests for accommodation in a timely manner. That doesn't always mean right away. Sometimes employers are entitled to take some time to consider what accommodations are available and what they can do with the resources they have. But they have to be reasonable about that. They can't wait a very long time. They're supposed to respond to your request fairly quickly. Can we go to the next slide, please? Thank you. The law of human rights also creates what we call a duty to inquire on the part of the employer. And what this means is if the employer notices that an employee is struggling at work, and there is some reason to believe that that could be connected to their disability, the employer should talk to the employee about whether they need accommodation. It is certainly, most cases, it is easier if the employee who requires accommodation brings that up with the employer. But sometimes that doesn't happen. And in some cases, if an employee is fired for a reason related to their disability, that might be a form of discrimination, even if the employer did not know about the disability. And those are the cases where the employer has a duty to inquire about whether there is a disability or some other factor that is affecting a person's work. The most common example of this is when someone has worked in the same place for a long time. Let's say they've worked there for many years, and all of a sudden their work performance changes drastically. If it gets worse very suddenly, most of the time in a case like that, the employer would not be entitled to fire them right away. The employer would have to take some steps first to ask the employee, is this change in your work, is this related to a disability? Is there some reason to think that the employee might need accommodation in order to keep doing their job? So the bottom line is this means that the employer usually has an obligation to ask questions about whether a disability is causing performance problems on the job before the employer decides to fire a person. Can we go to the next slide, please? Thank you. So this slide starts to get into some of the employee's responsibilities. In other words, your responsibility as a person with disabilities who might be requesting accommodation in the workplace. Generally, the employer should try to tell the employee, the worker, should tell the employer if they need accommodation. They should explain how their disability affects them so that the employer understands what types of accommodation might be reasonable. And the employee also has a responsibility to consider any of the employer's ideas about accommodation in good faith. So this means even if the employee asks for one type of accommodation and the employer offers something different, generally the employee, the worker, they have to give that offer a fair chance. And they should only reject it if there is a very good reason for them to reject it. I also want to say, as part of the employee's responsibilities, generally the employee, the worker, has to provide enough information about your circumstances to justify the accommodation that you're seeking. And once again, you have to consider alternative forms of accommodation suggested by the employer, because as I said before, the legal requirement for the employer is to provide reasonable accommodation, not necessarily perfect accommodation. And the last thing I want to add for this slide is, I would also add that whenever you're communicating with your employer about accommodation or about your disability, if possible, I would recommend putting it in writing so that you have a record. And when I say in writing, it could be an email, it could even be a text message, or it could be a letter. The important thing is that you keep a copy, that you know exactly what you told your employer, so there's a record of it. And the employer can't later say, oh, well, I never knew that you had this disability. I never knew that you needed this type of accommodation. Sometimes it's necessary to be able to prove that you asked for that form of accommodation in case the employer happens to forget about it. Next slide, please. Another thing that we very often get questions about at the Disability Law Clinic is we hear from workers asking if they have to disclose their disability. And the answer is no. You are definitely not required to disclose anything related to your disability. You're entitled to keep that completely confidential unless you want accommodation. If you are seeking accommodation, or if you believe that your disability might affect your work, it is usually a good idea to disclose your disability to the employer. And when I say that you must disclose your disability, I'll talk more about this in a second. It doesn't mean that you need to tell the employer, to tell your boss your diagnosis, or even to tell them what is the name of your disability. But it is usually important for the employer to know how the disability affects you, and particularly how it affects your ability to do the work that you're supposed to be doing. And that's why I recommend that if you do decide to disclose, you should consider trying to get a doctor's note. And I say doctor, but it could be some other healthcare provider, like a psychologist. In some cases, it's very helpful to have something from an occupational therapist. If possible, to get a note like that to describe any effects that the disability might have on your work. Now, I said before that if there's any costs for that, it's generally, it's almost always the employer that must pay those costs. However, if it's something that you can do easily just by having a conversation with your doctor to get a note like that saying how your disability affects your ability to work, I would recommend doing that as part of your process of disclosing your disability to the employer. But I want to stress again, you certainly do not have to tell the employer you have a disability just because you have a disability. If it doesn't affect your work, that is your business and no one else's. But if there's any chance that it will affect your work, or if you believe that the employer is probably going to find out anyway, then I would usually recommend that it's best for the employer, for the worker that is, to bring it up, to be proactive about it. And once again, just to reiterate, you don't have to say the name of your disability. You don't have to give your diagnosis. The only important thing that the employer needs to know is how it affects you and your ability to do your work. And if possible, it would be great if that information about how it affects your ability to work comes from someone like a doctor or a psychologist or someone else who has expertise and knows you well. Next slide, please. So this slide lists a few more responsibilities that the worker or the employee has. As I said before, the accommodation process is sort of a give and take compromise process, and the employer must participate in it by providing reasonable information that proves they have a disability and that explains how that disability affects their work. The employer can ask for medical information, like a note or from a doctor, and what they can ask about is how the employee's disability affects your ability to do your job. And they can also ask if the employee is complying with their treatment plan. The employer cannot ask for details of the treatment plan, but they can ask for confirmation that you're doing what your doctor recommends. So let's say, for example, that your doctor's treatment plan involves taking certain medication that would help you to do your job. The employer could ask you to confirm that you're taking that medication. They can't ask you what the name of it is. They can't ask you what type of medication it is or what it does. But if the doctor says that you need medication to do the job, the employer is allowed to ask for confirmation that you are taking that medication. I think that's all I had about the employee's responsibilities. Can we please go to the next slide? Thank you. Okay, so now I'm into the sort of the final parts of my presentation. Oh, wait, let me take that back. There's a couple parts left to go. But I wanted to give you some examples of types of accommodation that I have seen happening in different workplaces. And I want to stress these are sort of general examples. Many of them will not apply to you. Many of them will only apply to people depending on the specific nature of their disability. But some of them are things we see happen pretty commonly. So the examples I've got listed here are sometimes accommodation requires the employer to modify your duties at work. For example, they might have to give you more breaks throughout the day. You might want to ask for more frequent check-ins with a supervisor to confirm that you are doing the job as it's supposed to be done. Sometimes it's reasonable to ask the employer to change how information is shared. For example, by giving you information or instructions in writing instead of verbally. Another common form of accommodation is modifying the work area, the workspace where you work. And again, this depends on the type of job it is, but many common strategies include assessing your work area for ergonomic barriers or challenges, or changing the lighting in your workspace, and this applies particularly to people with disabilities that affect their vision. And in many cases, a form of accommodation I see is moving someone's work area to be closer to required equipment. For example, if someone has to do a lot of printing or a lot of photocopying and they have a mobility issue, then it's probably reasonable to ask the employer to either move their workplace closer to the photocopier or the printer, or move the photocopier or printer closer to where the person works. Can we go to the next slide, please? I've got just a few more examples here of possible workplace accommodations. Sometimes it means providing special equipment to employees. For example, screen reader software, or earphones or microphones, or a hands-free telephone. Sometimes it includes different type of technical, well, I guess I'm talking about sort of IT equipment, like different types of computers or different types of what's the kind of software that I'm trying to think of? Sometimes it requires software that makes your job easier. I guess we've mentioned screen reader software here. And then the last example I've got listed here is giving time off to access treatment. And this has happened to most of us at one time or another, right? Where we need some time off work to attend a medical appointment. But we know that for people with disabilities, depending on the nature of the disability, you might require a lot of time off work to get treatment. So sometimes the employer has to accommodate you by just making sure that it's okay for you to take a few hours off work each week, or a few days here and there if you have longer appointments. But it can also mean allowing a longer leave of absence, like weeks or months even, if you need time to get treatment or to recover from treatment. The employer is generally required to give you a leave of absence and hold your job for you while you're not there, if the reason you're not there is related to your disability. Now, Now, at this point, I think we're doing okay for time. So what I want to do is just see if anyone can think of any other examples of things an employer could do that might count as reasonable accommodation for a person with Parkinson's or other types of disabilities. If anyone has any suggestions, I will encourage you to put it in the chat right now. I think in this format, you're not able to just say it out loud, although if you can, that's fine. But if anyone has any suggestions, please feel free to put that in the chat. And I know that that's sometimes helpful for your fellow participants here to hear some other types of examples of accommodation that they might have seen.
Yeah, so they can type in the chat box, and I think somebody has, but there is a raised hand function where someone can ask verbally as well, and then I can monitor that and let them speak.
Great, thank you. And so I see there's a question in the chat about, is there any time length restriction to time off if a worker needs time off to get treatment or to otherwise deal with something related to their disability? And that's a good question. And I think the answer goes back to what I said before about undue hardship. So it's going to depend on, for example, the nature of your employer. If you work for a really small business and there's maybe only 2 or 3 employees, there might be some restrictions. They might be able to say at some point, you know what, we can't wait for you to come back to this job any longer. But if you work for someone like the government or a big employer, generally they're required to give you as much time off as you need in order to be able to return to work. The only limit on that is if it becomes clear that you're not going to be able to return to work. If it becomes clear that whatever treatment you get, you'll never be able to return to that job. At that point, the employer can say that the employment relationship is over and they don't have to give you a chance to come back. But it usually takes, that is a drastic action, right? That is only when it's clear that no matter what treatment you get, you're not going to be able to come back to that job. Other than that, there's not too many limits on the length of time that you can take off, that the employer has to give you, as long as it's clear that you that it's related to your disability.
We do have a raised hand, so I will let them speak. 1 second.
Questions in the chat, which I will try to get to in just a second.
Okay, go ahead, Mr. Shaman.
Yeah, my name is Sujat Chamanor. So my work involves mostly supervision. I work in a research lab. I have mobility issues. I'm 39-year-old, diagnosed with early onset Parkinson disease. I have weakness on my right leg and right arm. So I don't have issues with driving. But can I request a work from home status for my work? Is that something I can ask?
That's a great question, and it's one that comes up very frequently these days. It's it's not an easy question to answer. When you talk to a lawyer, you're often going to get the answer, well, it depends. And in this case, it really does depend on the situation. It's going to depend on what the work is and what medical evidence you have to support the request. So I should start by saying, you can certainly ask for it. I don't know your employer, of course, but generally I would say there's never any harm in asking. However, in some cases, the employer might say no. And in that case, it might be up to you to provide the information that supports your request. And in this case,
Okay.
you need would be, first of all, you'd probably need like a note or a report from your doctor explaining why it's important for you to work from home. But also, the employer is in some cases allowed to say, you know what, this type of job can only be done in the office or on site or at a specific place. And so it's really going to depend on the nature of the job. For example, many types of office job you probably could do at home. Whereas if we're talking about like an outdoor job doing, construction, for example, that's not something you could do at home. So it's going to depend on the facts of your case, but I guess I would start by, or go back to saying, it probably doesn't hurt to ask, but before you ask, I would recommend having a conversation with your doctor and seeing if your doctor can support your request for you.
Yeah. Yeah. Thank you. Thank you so much.
You're welcome. I want to address a couple of other things in the chat. There's a question from Otto about whether the employer is required to pay for time off related to this, if you have to take time off related to your disability. Unfortunately, the answer to that is no. Some people have an employment contract, or if you're in a union, you might have a collective agreement that says the employer has to give you a certain amount of paid sick days, but there's not necessarily a requirement for the employer to pay for time off related to your disability. If you don't have a contract and you're not in a union, then unfortunately it's usually up to the employer, and if they say they're not able to pay for that, probably they're entitled to make that decision. I want to address Colin's comment in the chat. Colin gave a really good example of one form of accommodation. He says, Colin says, I'm a shift worker and I've been accommodated to have my shifts start at different times. I still work the same number of hours, but I start later in the day and I don't work all night. All in all, way better sleep. And I think that's a great example of accommodation, right? If you can get a doctor's note or some other evidence that supports that you need that change of your schedule because of your disability, then usually that's something the employer can accommodate. I could imagine in some cases that might make other employees feel jealous or say, well, how come this person gets special treatment? But that's the kind of thing where in order to accommodate you, the employer is supposed to put up with that, right? If other workers are inconvenienced, I don't want to say that's their own problem, because I think we do need to be fair to other workers, but the employer still has to do it, even if it creates inconvenience or creates jealousy for other workers. And I see one other question in the chat from Selena about whether an employee can request time or space to stretch or do exercise at the office if that is required to manage the effects of the person's disability. And I think that's a great question. And I would say probably probably an employee can request that. In fact, an employee can definitely request it. Most of the time, the employer should be able to accommodate that. I suppose there might be some workplaces where that might create some safety issues or otherwise, but I think that would only be in very narrow circumstances. In any kind of office job, for example, I think that would be a perfectly reasonable thing to ask. And I would hope that in most cases, an employer wouldn't ask for medical documentation, because to me, that seems like a very reasonable thing to do. And Cjo has another question in the chat about how do I deal with a situation when a request for accommodation results in termination from work? And I'm going to be talking about that in just a few minutes. In fact, maybe I'll move ahead with this presentation, because I think I want to address that question before we go.
Patrick, it will be available. I see there's a question. It is recorded. Andrew, I just had one question. Can I ask?
Yes, for sure.
So if an employer is providing accommodations, can they come back at a later point and say that it's no longer sustainable and ask the employee or tell the employee that they need to take a leave of absence and perhaps go on disability? Can they do that?
In some circumstances, the employer probably would be entitled to do that. And again, it's going to go back to this question of undue hardship.
Right.
So it's going to depend on a lot of factors, including what the employer's resources are. So I mean, I could imagine situations where, for example, an employer is a big business and they have a lot of resources, and they really, in that case, have to accommodate you in almost, for almost in many cases. Mm-hmm. But let's say business gets really bad, and after a year or two, they don't have as many resources as they used to have because they're not bringing in as much money. In a case like, I mean, that's just one example that springs to my mind, but that's like, I could imagine situations where an employer is allowed to do that.
Right.
But I would say I would be very skeptical of it, right? It's something that if I was an employee in that situation, I might want to seek legal advice at that point, because maybe the employer's allowed to do that in some cases, but only in very limited cases. Most of the time, if the employer has allowed you has agreed to some form of accommodation, unless something changes for the employer, the passage of time on its own is not going to be a good enough reason for them to stop giving you that accommodation.
Okay, thank you.
You're welcome. Can we go to the next slide, please? Okay, so this is where we're going to try. I'm going to try to answer some of Cjo's question. The next few slides are about taking legal action to enforce your right to accommodation. And I would say this is really a last resort, right? If you have asked for accommodation and you've provided information to support your request and the employer just isn't being reasonable, or certainly if they fire you because of something related to your disability. In that case, you might have to take legal action, but I do have to say, taking legal action to enforce your rights can be very stressful. It is almost always a slow process, but unfortunately, sometimes it's the only way to make sure human rights laws are respected and people get the accommodation they need. Can we go to the next slide, please? So what you can do in this case, if the employer is not following their obligations to respect human rights and accommodate you, you can submit a human rights complaint. Most employers are regulated by the provincial government, so complaints would go to an organization called the BC Human Rights Tribunal. For some employers who are regulated by the federal government, complaints go to the Canadian Human Rights Commission, and I've listed the websites for both those agencies there on the slide. And then for employees who are members of a union, they may be able to enforce human rights laws through the grievance arbitration process if their union supports them. Now, unfortunately, the human rights legal process is slow, and it can take many years from when a person starts the complaint process to when the tribunal finally makes a final decision about it. But sometimes it's worth the wait, because in some cases, the tribunal can force businesses and governments to make major changes to how they operate. As for grievances in a unionized context, the time that grievances take can vary, but in general, a grievance takes a lot less time than a human rights tribunal case. So that's one advantage that employees have if they're in a union. Can we go to the next slide? Thank you. So this slide is about seeking legal advice in order to enforce the right to accommodation. I'm putting a little bit of legal information in here, but I can't emphasize enough how important it is to get legal advice if you're considering a human rights complaint. There are deadlines you need to be worried about. There are questions about where you send your complaint, whether it's to a provincial or federal tribunal. And all these issues are things that, if possible, I really want you to get legal advice about before you start this legal process, because it can be stressful. As it says here, I've just got a little legal information on this slide. The deadline for starting a human rights complaint is usually 1 year from the date of discrimination. But sometimes the date of figuring out what is the date of discrimination can be tricky, especially in cases where things happen over the course of a long period of time. The legal process is complex, and in some cases are dismissed for what I would call technicalities, for technical reasons that I would say are not always good reasons, but might count legally. And in most cases, the employer will hire a lawyer to try to prove that they did not discriminate against you. If you start a human rights complaint against them, they're probably going to hire a lawyer to fight you on that. And so if the other side has a lawyer, it's definitely better if you have some legal assistance to help you as well. Now, that's if you're doing a human rights complaint. If you're doing a grievance, if you're in a union and you're going through the grievance arbitration process, you should talk, if you want to file a grievance, you should talk to your union as quickly as possible if you believe that you were discriminated against. The process and the deadlines that you have to follow are set out not in the law, but in the collective agreement. In other words, in the agreement between your union and your employer. So if you're doing a grievance, it's less important to get advice from a lawyer, but it's very important to talk to your union as quickly as possible if you feel you've been discriminated against. Now, I know it can be difficult to talk to a lawyer if you're not in a union and you don't have a lot of money, but it can make a very big difference to the outcome of a human rights complaint. There are some organizations that can provide free legal advice about human rights. And one of those organizations is the Disability Law Clinic, where I work. But like many of these organizations, there's a lot of demand for our services. And unfortunately, we can't always respond as quickly as we would like to. And we can't always provide as much assistance as we want to. But I would still encourage you, if you're considering a human rights complaint, call the Disability Law Clinic, or else find go online and search for a lawyer who can help you, search for places where you can find free legal advice. Even if you only talk to a lawyer for a brief period, like for half an hour or an hour, that is often better than nothing in terms of making sure that your human rights complaint doesn't get dismissed based on a technicality, and that you file it in time, and to make sure that your rights are protected. Next slide, please. Okay, so I'm almost done here, but before I conclude, I want to talk briefly about a different type of law called an accessibility law, because I believe that might be like the future of accommodation. And I say future because this is a new type of law that we've only seen in Canada in the last few years. The main difference between accessibility laws and human rights laws, which is what I've been talking about so far, is that human rights laws require individuals to complain about discrimination. For example, if you're an employee, you have to start the process of complaining about discrimination before anything can be done to fix the situation. If your employer is not respecting your rights, it's up to you to take legal action to enforce those rights. But with an accessibility law, the purpose of these laws is to prevent discrimination from happening in the first place by ensuring that people with disabilities do not face barriers at all, by creating rules to prevent workplace discrimination and other forms of discrimination from happening in the first place. Here in BC, we just created a law like this a couple of years ago, back in 2021. And it's going to be implemented very slowly over the next several years. And that's normal. It takes a long time to implement these laws because they are supposed to change large parts of society in very significant ways. So we've already seen laws like this created in Ontario and Manitoba and Nova Scotia. And there's also a federal government version of this law in areas of life that are under the federal government's control. But here in BC, although the law has been created, it hasn't really been implemented yet. So we don't know for sure how it's going to work in BC, but there is definitely a great potential for accessibility laws to make accommodation to make it work better and to prevent discrimination, particularly in the workplace, from affecting people at all, so that hopefully there's less need for people to file human rights complaints. Can we go to the next slide, please? Thank you. So I'm just going to talk briefly about how accessibility laws work, because this is looking towards the future. This is not really happening in BC yet. But the way they work is the laws themselves do not contain specific rules about accessibility. Instead, they set out a process that governments must follow in order to make those rules. And those rules are called accessibility standards. And accessibility standards are specific rules to ensure that people with disabilities do not face barriers. Can we go to the next slide, please? The goal of accessibility standards is to make society more accessible for people with disabilities by removing barriers proactively instead of waiting for people to complain about specific cases of discrimination. And accessibility standards are going to apply to all sorts of areas like transportation, the built environment, in other words, like roads and sidewalks and parks and anything that the government builds. They're supposed to apply to government services like education and healthcare, and they're supposed to apply to employment. Now, unfortunately, even in the provinces that do have these accessibility standards, we've seen that in some cases, enforcement is inconsistent, and so sometimes people get away with not complying with the standards. Excuse me. But I still feel that these are a step in the right direction. And I just want to give a few more examples of what what accessibility standards might look like, because we haven't seen any in BC yet. We're still waiting for that, but we've seen them in other provinces. So one example is we've seen in Ontario, for example, now employers, or big employers anyway, are required to create individualized accommodation plans for all employees with disabilities. And for those of you with children in school, you might be familiar with schools are already required to create individual education plans for students with disabilities. And the idea is that's going to be expanded so it applies to employment as well. In other words, when you start a job, if you have a disability, the employer has to you have to work with the employer to write down all the things that the employer is going to do to accommodate you. And that list can change over time. But the important thing is there's a list, there's something you can refer to in writing that says, here's what the employer is going to do for you to accommodate you. That's just one type of accessibility standard, but they can mean all sorts of different things. And so another example could be We've seen in some provinces that there's specific requirements for example, ramps in public transportation and indoor and outdoor spaces, or requirements that benefit people with mobility issues, requirements like curb letdowns and accessible parking and accessible trails to playgrounds and beaches and things like that. So these are just some examples of what accessibility standards might mean. The list of possible examples is almost endless, like anything that can be done by society to make sure that people with disabilities face less barriers in their life could become an accessibility standard. Here in BC, we're still waiting to see what that's going to look like. I am cautiously optimistic about that. I think it's a step in the right direction that we're doing it, and I think that we need to pressure the government to make sure that the new Accessible BC law does everything we want it to do. It reaches its potential to help people with disabilities. Next slide, please. I'm down to I think this is my second last slide now. I listed some resources here where you can find further legal information about human rights and disclosure and accommodation for people with disabilities. And don't worry if you don't have time to write all this down. I realize those are sort of long links listed on the page, but I know that these slides are going to be posted on the Parkinson Society website. So if you don't have a chance to take all this down now, I'm sure that you're going to be able to find it later when this is posted on the website. And do I have just one more slide, I believe? Oh yeah, okay, so this is my last slide. And I really hope this presentation has been helpful. And I want to thank you all very much for the opportunity to speak to you and to the Parkinson Society for having me here today. And I know we have a few minutes left, and if there are any questions, I would be happy to try to answer them at this point. Oh, and I do see a question in the chat from Marla about should people with Parkinson's apply for a handicap sign for their car, or is it a case-by-case situation? I have to admit, I don't have a lot of expertise in that process, but I think it probably is fair to say it's a case-by-case situation. I know that, like many conditions, Parkinson's affects different people in different ways. So some people would absolutely be entitled to having a handicap sign or an accessibility sign on their car so that they can park in accessible parking spaces or handicap spaces. But I think it's something you have to deal with in a case-by-case situation. I know it's an organization called Spark BC that handles those signs. Unfortunately, that's pretty much all I know. I couldn't. I'm afraid I can't give you too much more information about that. And I see Nora has a question that they're on Canada Disability. Can your doctor put you on disability for taxes? I think what Nora is talking about is the disability tax credit. Okay, thank you, Nora. And if that's the case, so your doctor can definitely support your application for the disability tax credit. They don't get to make that decision on their own. It's a government decision about whether you're going to get that tax credit. I don't have a lot of expertise on the disability tax credit, but I know that there's a program at Disability Alliance BC where I work called Access RDSP, and they really focus on helping people to apply for the disability tax credit and to open a registered disability savings plan. So for more information, Nora, I really hope that you will consider contacting Disability Alliance BC. And if you search for us online, you should be able to find our contact information. And if you call our office, someone there will be happy to talk to you about how to get the disability tax credit. I don't know for sure how long it might take them to get back to you. I know that they're pretty busy, but I know that they can help. They'll do their best to help you. All right, well, thank you again, everyone, and thanks to the Parkinson Society. The last thing I will say is if anyone does have any particular questions about their legal rights, if you're having difficulties with your employer, please do feel free to contact the Disability Law Clinic. We can't always solve your problems, but we will do our best to make sure we can try to give you some helpful advice and point you in the right direction.